Welcome to The Explainer. Today, we're diving into a landmark court case that gets right to the very heart of your digital privacy, especially in a world where we're all sharing spaces and, of course, sharing devices.
So let's just start with a question that might hit a little close to home. Think about the devices you share every single day. Your family tablet, the computer in the living room, maybe you even share a laptop. If the police were to show up at your door, who really has the right to hand it over? Let's find out.
All right, here's how we're going to break it all down. We're going to start with the dilemma of the shared computer, then trace the legal battle as it made its way through the courts. We'll dig into your right to privacy, then get to the big one, what the Supreme Court decided. And finally, we'll talk about why this case really matters.
Okay, so let's set the stage. Our story kicks off with something a lot of us can relate to, a shared home and a shared computer. But it leads to a pretty shocking discovery that would end up testing the very limits of digital privacy in Canada.
So here are the basic facts. You've got a couple, Thomas Reeves and his spouse, sharing a home and a computer. Now, after a domestic dispute, his spouse contacts his probation officer. She reports that she found what she believed to be child pornography on their shared computer. A police officer then comes to the house, but, and this is the really critical part, he doesn't have a warrant. He later said he didn't think he had the grounds to get one, so instead, he just relied completely on the spouse's consent. She signed a form, and the officer took the computer from a shared area in the basement.
That single act, seizing a computer without a warrant, kicked off a legal battle that would wind its way all the way up to the highest court in the country. Let's see how that whole fight unfolded.
So, at the very first trial, the judge actually sided with privacy. They ruled the seizure was unreasonable, threw out the evidence from the computer, and Mr. Reeves was acquitted. But the Crown, that's the prosecution in Canada, they appealed it. And the Court of Appeal flipped the decision, arguing that on a shared computer, Mr. Reeves's expectation of privacy was, quote, greatly diminished. So they ordered a new trial. And this major disagreement between the two lower courts is exactly why the Supreme Court of Canada had to step in and give a final answer.
Now, before we get to the final verdict, we have to understand the crucial legal principle that's right at the heart of this case. And it all comes down to a short but incredibly powerful section of the Canadian Charter of Rights and Freedoms.
And this is it, Section 8. You can think of it as a constitutional shield that protects our private lives from the state. It guarantees our right to be safe from unreasonable search or seizure. Now, that word unreasonable is everything. It's not an absolute right. So what makes a search reasonable, especially without a warrant? Well, the courts have a specific test for that.
To figure out if Section 8 even applies, the court uses this four-part test. They look at the subject matter, the person's direct interest in it, whether that person personally expected it to be private, and then, and this is the most important part, whether society as a whole would find that expectation to be reasonable. You see, this last step is where the whole shared computer thing gets really tricky. I mean, is it objectively reasonable to expect privacy in something you don't have exclusive control over? That was the big question for the Supreme Court.
Okay, with all those principles clear, let's get to the climax of our story, the final decision from the Supreme Court of Canada, a decision that would set a huge precedent for our digital privacy rights.
The court's answer? It was crystal clear. They sided with Mr. Reeves and allowed his appeal. They overturned the Court of Appeal's decision, threw out the computer evidence, and put the original acquittal back in place. Plain and simple, the seizure was unconstitutional.
Justice Karakatsanis, who wrote for the majority, put it perfectly. The court basically declared that just because you share a device with family or friends doesn't mean you're surrendering your constitutional rights to the state. One person can't just waive another person's charter rights. The court drew a really important line. The risk you take is that your partner might see your files, not that your partner can authorize the police to seize the whole device.
But here's where things get even more fascinating. While every single judge agreed on the outcome, that the evidence had to go, they fundamentally disagreed on the legal reasoning. And that revealed this deep debate about what a seizure even means in our digital age.
So the majority, they focused on the data. They said the police were really after the private information on that computer, which the spouse had zero right to consent to. But Justice Coutet saw it differently. She argued that the spouse, as a co-owner, could consent to handing over the physical device, the actual box. For her, the constitutional problem wasn't the seizure itself, but what happened next. The police held the computer for over 4 months without reporting it. It's a subtle difference for sure, but a really critical one for figuring out exactly where the state crossed the line.
So what does all this high-level legal debate actually mean for the rest of us? Why does the difference between seizing data versus seizing a device even matter? Let's break down the key takeaways.
Well, this decision really strengthens digital privacy for all of us. It confirms that your constitutional rights don't just disappear because you share a laptop. A roommate or a family member can't just give the state permission to take your entire digital world. The court recognized that our computers hold a, quote, biographical core of personal information, basically our whole lives, and that gets the highest level of protection. So the bottom line is pretty clear. If the police want to seize a computer from a home, they generally need a warrant.
You know, the Reeves case answered a critical question for shared computers, but it leaves us with an even bigger one to think about. As our lives get more and more interconnected through shared cloud accounts, smart home devices, family data plans, the lines of our individual privacy are only getting blurrier. This case is a vital landmark for sure, but the conversation about our digital rights, it is far from over.